Hi, my name is Brad Micklin. I'm an attorney and managing member of the Micklin Law Group, which is a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. One of the most difficult issues inside of divorce and family law are restraining orders. And they're more complicated when there is a narcissist who made the allegations against you. People will often ask me, what happens if I'm dealing with a narcissist and that person files a restraining order against me? I think there are several aspects to preparing for a restraining order, whether or not there's a narcissist involved. First is the restraining order aspect of the case. In order to prepare for any restraining order, I think you need to understand the law regarding it. So first, I recommend that you review the statute. It's very easy to find. You can run any kind of web browser search, put New Jersey domestic violence statute, you'll go right to it. You want to read what the statute says and what needs to be proven by the other party when you appear for trial. Second, you want to read the restraining order that's filed against you. Check the dates, check the allegations, find out whether or not they're consistent with one another, and try to go back and find out where you were on these days, what evidence you had to support whether or not you were there, and whether or not any of the allegations are even remotely true. Lastly, you want to talk to people that may serve as witnesses for you. People that either know the other party, the relationship that you two share, or the dates that are raised in the restraining order as a possible defense witness. But you want to speak to them first to make sure that they're going to be favorable for testimony. Next, and probably more important, is you need to understand the person that you're dealing with if he or she is a narcissist. And I use the term narcissist even though I'm not a psychologist, but it's a term that's often used. And first you need to understand that everybody's narcissistic to a certain degree. That's why I'm sitting in a suit, my hair is combed, and I'm trying to be presentable. But there's a spectrum for narcissism. And the further that a person is on that spectrum, the more difficult they are to deal with. So if you're dealing with somebody who is what I call a hardcore narcissist, you're dealing with somebody whose self-image is most important to them. So first, they need to be consistent with the stories that they tell, whether they're true or not. So if you're facing a restraining order, the allegations may be patently untrue, they may be egregious stories. They will in fact believe them, and they will do whatever they can to present a credible, honest presentation of that information because they need to be believed. The problem is, the more egregious an allegation is, the more believable it will be, because the common thought between judges and lawyers and practitioners is people tell the truth. As ironic as that may be, and as difficult to understand as that may be, people are presumed to be telling the truth. So you will find yourself defending against an egregious story and running uphill in order to do so. So you need to be prepared for this realistic approach, because you might be charging uphill to defend against something that's just not true. Lastly, you need to be prepared for trial. Most matters, including domestic violence matters, will often settle before trial. But if yours is going to go to trial, you need to be prepared for testimony. It's not just about telling the truth, which of course you're supposed to do, but it's how you tell the truth. Judges will look to your body language. They will look to your eye contact. They'll look to consistency in your recollection of dates. If you have evidence that you want to present, you need to make sure that you have it produced for the court. You can't just bring in your cell phone. You need to have audio put onto some kind of disk drive. You need to have text messages and emails, if applicable, printed out and ready for the judge to consider. And you need to have your witnesses prepared to the extent that you can without telling them what to say, but you want to prepare them for what they're going to be asked and what you need them to testify about. If you'd like more information on any of these topics, you can go to our website at micklinlawgroup.com.